Well, these are amendments that most of your members probably would know have come into effect this year. They form part of a plethora of new laws that surround how you are to deal with an employee. And these laws sort of marry in with existing laws, both on occupational health and safety and a bit around flexible working. So we will get into the minutiae of all of those different types of leave and how they interact. But firstly, the official definition of what family and domestic violence is. It's got a two-pronged approach. The first is that it has to be family or domestic violence that is violent, threatening or abusive behaviour, which is in itself quite self-explanatory, but this part of it by a close relative of an employee or a member of the household. So that's who the perpetrator needs to be, is a close relative of the employee, a member of the employee's household, or a current or former intimate partner of the employee. So that's part one. And then part two is that that person has to be seeking to coerce or control the employee and cause the employee harm or to be harmful. So it's really important that both of those are considered when determining whether family or domestic violence leave is to meet the minimum threshold for what it is. That being said, I will put the caveat on that there are a lot of employers that are going beyond the minimum. This is the minimum standard, but we always recommend that as these laws develop and we understand through case law what they're going to mean, people adopt it with their own processes and procedures and policy that would overlay any minimum entitlement at law. So, but it is a new concept on its standalone. It's always sat family and domestic violence as a matter relevant to asking for a flexible work arrangement, but it's always been on an unpaid basis if it was taken. So this is sort of bringing it in line to be paid by the employer in those specific circumstances.
Yeah, right. And I understand there's different types of domestic and family violence. Would you mind just explaining some of the different types, I guess, for people to look out for?
Yeah, so people obviously know and think of the physical side of domestic violence, which is obviously usually or likely to be the main component. But there are different types that exist, and you need to turn your mind to what it is when you're considering a request by an employee. Now, what the law is that it can form many different parts or different types of behaviours, and that includes, as we said, physical, which most would recognise, sexual assault or sexual abuse, again, which most would notify or understand. The others come into these areas where you might need to turn your mind to thinking about a bit differently, which is verbal abuse, emotional or psychological abuse, stalking. That's a big one that obviously can often marry in with some of the other types of domestic or violence, family violence. Financial abuse, and that's relating to, restricting money or dictating money. Spiritual or cultural abuse, that's a sort of difficult one to conceptualize, but it is obviously abuse around someone's beliefs or practices. Serious neglect where there's a relationship of dependency, damage to property, technological assistance, or abuse or threats. So of pets, which again, that's one outside of the square, what we'd all normally think. So when it comes back to that about the control and seeks to harm, this is where the assessment of all these different types of leave will come into play. So yeah, open your mind beyond what it is and assess each one on an individual circumstance would be my tip.
Absolutely. And I guess there's a lot of thinking around the physicalness of it, but certainly when it's more broadly like this, there's a lot more to it that can certainly impact somebody's life. Absolutely. So what are some signs, I guess, for businesses to look out for that an employee may be experiencing family and domestic violence?
So there's a fine line between obviously looking after and caring for your employees and showing that that you do care about their circumstances, and invasion on someone's privacy. So I think it is a fine balance to know how you should approach signs if you see them and what you should do. So obviously, as an employer, you have an absolute obligation to ensure people's health and safety. Now, what's happening at home does not necessarily refer to an employee's health and safety at work, but it often can, either by it coming into the workplace, by, say, a partner turning up at work, or by, the employee being put in situations at work which may exacerbate or bring to light those issues. So with caution, I say look out for signs and then approach it in the appropriate way that you would think that employee would like to be approached. So that could be through HR, that could be through your EAP service, reaching them out. It could be by discussions with next of kin and things like that. But yeah, you'd need to look at each scenario and see what it is. But some signs are like excessive or unexplained absences, or late to work, or, stress about leaving on time. They always can be signs about a pressure at home that needs to be be dealt with. A sudden or sustained drop in productivity. Obviously, if your mind's elsewhere on matters, it will flow on to your work performance. Unexplained injuries, obviously that's an obvious one. Social withdrawal, so yeah, from the workplace, if there's been a heightened or a definite withdrawal from previous behaviours. Frequent or unusual work breaks, they're going out on their breaks and on their phone and coming back stressed. Anxiety or fearfulness, that's obviously an obvious one. Appears distracted, depressed or overly jumpy, that's again an obvious sign usually. A lack of concentration. An inability to work or take work-related trips, that comes down to a personal pressure, and then the personal calls, etc. So these things can all obviously be signs of things other than domestic or violence. They can be just everyday pressures, and that's where I caution jumping to a conclusion about something. But on the same thought process, you can never overcare for your employees. You can never care for them enough. So just checking in about their well-being and checking that they're okay by the appropriate person will help you identify it early. And obviously, the earlier you identify it, the earlier it is resolved, and hopefully there's a path forward for both the employee and the employer. If they get their employee back who's engaged, driven, and who you want at the workplace. So there is mutual benefits in detecting it early.
Yeah, absolutely. And I guess that key message of working in with your staff, picking up on some things that might be just a little bit out of the ordinary on their individual reactions or the way that they're presenting for work. Yeah, that's really helpful.
And I wouldn't jump to the question. I have to ask: are you suffering domestic violence? You would approach it in a caring, practical way. That may be having a female approach. If it's a female, it may be, as I said, through HR or through an EAP service or otherwise. So you can do it without putting the employee in a difficult situation.
Yeah, absolutely. So what are some of the obligations as an employer?
Okay, so in regards to the domestic and family violence, or family and domestic violence leave as its own, there's a two-pronged approach to the change in legislation. If you're considered a small business, so that's less than 15 or less employees, these changes don't come into effect to the 1st of August. If you are not a small business, then they've already come into effect as of the 1st of Feb. So what the entitlement is to 10 days paid family and domestic violence leave. And that leave entitlement accrues from day one of employment. So if someone commences employment today and you're not a small business, then they automatically have a right to take 10 days family and domestic leave from today. So that's a differential factor to other types of leave, obviously, which accrue over time. This is, you get 10 days on employment, and then that 10 days renews every 12 months. So it doesn't accumulate. So you will only ever have a maximum of 10 days in your bank, but it's 10 days. They can take that 10 days over a 12-month period. Whether they do or don't take it is irrelevant. It then starts again at 12 months and you get 10 days back. So that's a real important thing. Don't think they have to pass probation or accrue it before they get it. They get it from day one. As I said, for small business, that paid part of it doesn't start till the 1st of August. But what's in play now before that is they're entitled to 5 days unpaid leave. So until the 1st of August, small business would have to allow it on an unpaid basis. From August, they have to meet the 10 days as well. So, but what's important to know, and we'll go through it, is how you treat that leave and how you record that leave is really very specific in these circumstances. But we'll talk about that further. As we talked about in the opening, family and domestic violence leave will come into play or be relevant to flexible working arrangements and health and safety. So everyone would be aware as what flexible arrangements are, and I don't intend to go into it in too much detail, but to say, obviously, if an employee approaches you for a flexible working arrangement, what used to be really easy, the employer just say, sorry, for operational reasons, we can't do that. The law doesn't allow that definite no with no explanation anymore. They're really tight timeframes around what you must do as an employer, what you must say if you reject or accept or propose an alternative, and that there has to be really good consideration given to that. What we're finding is post-COVID, there is a stronger argument, if I can put it that way, for flexible working arrangements, because a lot of employers, probably not so much in your industry, but a lot of employers had, work from home arrangements, had part-time work from home or otherwise. So they've got that precedent to be able to say, well, it's worked for the business. So during COVID, so why can't it work for me to meet my parental needs or my needs around assessing, in a custody battle or something like that. So tip is a lot more thought needs to go into it than it used to, and certainly a lot more written documentation and process needs to be followed. But that requests around domestic and violence leave on a flexible working arrangement really have to be taken seriously, and that have to be, in my view, a very, very good reason why you couldn't do it, and that might just be, okay, you're going through a court situation, how about for the next 6 months, it will allow you to work 4 days, and then you'll have a day to go and do what you need to do over the next 10 weeks, and then you revert back. So you can do it for a short period of time. It doesn't have to be ongoing, but that could be one way you would address it, to say you've got 10 days. How about for the next 10 weeks, you do 4 days work, you take 1 day family and domestic violence leave, and then we can assess this flexible working arrangement after that. So that's an example of how that you could, obviously deal with both. And so 6th of June was the date that those major changes came in about flexible work. So that's something, that we need to consider as we sit today for everyone. Workplace health and safety, I'll touch on it. Obviously, you have an obligation to reduce chore, work and health and safety. It comes into the workplace if, as I said, a perpetrator or otherwise might visit work, or police might come on to serve papers or otherwise. But what the main issue would be is if you see an employee who is vulnerable, who is not themselves, once you know that fact, and you may be exposing them to harm in the workplace because they're at that vulnerable place. So it's really important not to think, oh, that's just a home life matter, it's got nothing to do with work. That's not true. If an employee has changed considerably, they're suffering, and then their mind wasn't on the job and then they cut their hand off, or, in your industry, some workplace accident happened, that would be relevant to, work health and safety, and you take an employee as they are in those circumstances. So, you really shouldn't look at it in isolation, and you should consider these 3 heads as one.